Okay, well look, thank you so much for your time this afternoon. I hope you're going to enjoy this session and also perhaps learn a few new things about data protection and privacy. Obviously I have a bit of competition because there are lots of other presenters around me as well, but I have the benefit of having a microphone. I will be able to take questions either directly after this presentation or, better still, see me around this corner at R11, which is where the Henley Business School stand is, and you'll be very welcome to meet with me and my colleagues and we can talk to you a bit further. So let's just get going then. The title of the session is Game Changer, and that's going to be very apparent in a few moments. What I want to do is cover two things with you this afternoon. The first one is to give you an overview of the EU General Data Protection Regulation. The first thing is to talk about the EU General Data Protection Regulation. It actually replaced the existing Data Protection 95/46 EU Directive and will also replace the Data Protection Act of 1998. So stay tuned for that. And also what you need to do now in order to comply with the General Data Protection Regulation, which is currently and will be under a 2-year transition period. So this isn't about what's going to happen in 2 years' time. This is about what's happening right now. So there have been in the press, as you probably know, huge number of data breaches. And in fact, 2015 had the highest number of personal data breaches of any year since records began. You probably recognize some of the brands on that slide, and clearly it's caused a huge amount of consternation for an awful lot of companies, because it's very easy to be at the wrong end of a sanction from the Information Commissioner's office. And soon it's going to be very easy to be at the wrong end of a sanction from the European Data Protection Board. So it's very, very important that organizations protect personal data of their customers. And that's really part of the reason why we have a new law right across the European Union. As part of that process, we see training and education as being absolutely critical to business resilience. Without effective training and education, there's evidence to show that organizations will suffer increased levels of personal data breaches. So education and training is very important. It's a critical factor in how you reduce your risk for being fined, and we'll talk about the fines a bit later. So what we've done at Henley is we've created a unique program at the business school which takes people through both offline and online on the intricacies of data protection under the new regime. And it's aimed at people who are responsible for data protection and privacy within those organizations. We're fundamentally focused on financial services, but equally there are other sectors that are equally affected. So what we do with financial services is of equal weight for other organizations and other sectors. One of the things to recognize, and you may have picked this up in the media, that actually there's a package of reform that's going on right now. So the first package of reform is actually to do with criminal justice, cybercrime and terrorism, and sadly that's on the increase, not the decrease. So there's a whole directive that's focused on criminal investigation and crime and detection. That's not what we're going to be talking about this afternoon. What we are going to be talking about this afternoon is in fact the commercial side of that package, which is the General Data Protection Regulation. This is a piece of regulation that started in 2012. It's just going to be signed off by the European Parliament any day now. It's reached agreement between the European Commission, the European Parliament and the Council of Ministers. It's taken a very long time to get there. Don't get confused about whether we're going to be in the EU or not. It applies to any organisation that holds data of any European Union citizen or anyone within the European Union. So it's completely irrelevant whether the UK remains or leaves the European Union. This regulation will take effect in 2 years' time in its full effect, but there is a transition period, and what we're going to talk about this afternoon is what that transition period looks like and what you need to do in order to start to think about complying with this regulation. It's also about 3 times the length of the current Data Protection Act, so it's pretty fundamental as a piece of European legislation. It's the most scrutinised piece of European legislation ever since the Common Market. There are 3 key bullet points really in relation to the points I want to make this afternoon. The first one is that it's a massive game changer. And the way we think about data protection, the way we collect data from customers, how we use it, how we store it, and what we do with it is massively changed. The second bullet point is that it imposes a new raft of duties and responsibilities on both the data controller, and that's you as an organisation, but equally the people that you use to process data, data processors. And there are very clear duties and responsibilities under European law now that apply to both the data controller and the data processor. It also increases the fines that a data controller or data processor can be subject to, and it's as high as 4% of global turnover in the preceding 12 months, or 20 million euros. This is so beyond what the current sanctions and fines that can be imposed by any supervisory authority. So from that point of view alone, it's a massive game changer. The third point, which is quite important for all of us today, is to think about resources. This regulation, the GDPR, will require organisations to put aside budgets in terms of appointing a DPO, a data protection officer, and we'll talk a little bit about what that person's required to do. It will also require a budget for training, and training is in fact mandated under the regulation. So there's no escape for anyone not knowing what they need to do under the current law. An awful lot of organisations that we know and spoken to, both within Henley Business School and outside, have been sleepwalking about this. It's really time that they remove the blindfolds, if you like, and really start to understand what this means in terms of business continuity. So business continuity for all our organisations is something which is critically important. The GDPR, and I brought a copy with me, I haven't got it with me in my hand, runs to a large number of pages. There are over nearly 100 articles in there. And it is a bit like a game of snakes and ladders. You really do need to have a level of granularity of detail to make sure that you don't trip up and fall down a snake, but equally there are opportunities for organisations to demonstrate how they handle personal data in order to build trust with those customer segments and audience segments that they want to have a relationship with. Now, I'm here as Henley Business School, and you're with other organisations, but interestingly, a large number of very, very experienced lawyers, both in the UK and in Europe, have looked at this in some detail. And these are just 2 very important people, if you like, who have looked at the EU General Data Protection Regulation. It would be a huge mistake to ignore GDPR until it becomes enforceable. Actually, the word missing there is fully enforceable, and I'll tell you that in a minute, by 2018. Stewart Room is at PwC. This will impact every entity that holds or uses European personal data inside or outside of the EU. What we have done is really try to make this as user-friendly as possible. Interestingly, if you read the regulation, there's no index to it. It's actually quite difficult to navigate your way through what is quite a very dense regulation. So as part of our learning experience for people who come to Henley, we've actually instructed them as to how to read the regulation and also pointing to the important bits of it, which is of relevance for them, again, through the lens of business continuity. So very, very quickly, I'm just going to take you through very quickly what the components of this program is. We have an introduction part of the program, and we have an integration part of the program at the end, and in the middle we have 6 online modules. And we've calculated that if you go to the day and a half introduction, the 2 days at the end, and you undertake to do about 5 hours of online studying on this program, you should be able to complete the certificate in 5 months. So it's very important that people who are in this role as a DPO are actually given the tools, training and support and education they need to make sense of this new regulatory regime. And so we've managed to cram that into 5 months. The other unique thing about this is that we have a judge who will facilitate both the introduction piece at Henley. If you haven't been to Henley, do go there. It's an amazing business school. And he'll also facilitate the end of the program for the integration piece. So we've actually got a judge who I read law with who will be doing that with us. As you can see, it's quite detailed. And so again, not to labor too much on this slide, the first 100 days will indicate what one has to do as a data protection officer in your first 100 days in office. The second module is about the core principles of risk management, because a lot of this is to do with risk and business continuity. That's a really important module to make sure that actually the person in charge of data protection and privacy knows what they're doing. Then we look at the fundamental legal principles, and there are new legal principles in this regulation, and I'll be talking very briefly about some of them this afternoon. And then for an awful lot of people who come on this program, they are already experienced data protection people. And so what they need to know is what's the difference between the previous regime, the previous Data Protection Act, the previous Directive 9546 EC, and what's different or new about the General Data Protection Regulation. So instead of guessing that and trying to work it out, we present that piece of content to them very, very clearly. And all the way through, we are testing people's ability to understand not just the principles, but to actually problem solve through case studies, through scenarios, through questions. And at the end of each module, there is actually a test which you do have to pass. And if you are doing the program and you're keeping up with this, there shouldn't really be a problem. We're not expecting a high failure rate. Then I think what is unique about the program is that the last 2 modules focus on technology. One of the things that's happening in the market at the moment, as you'll see, there's an awful lot of 1-day, 2-day, 5-day programs which can't really go into the detail and the granularity of something as complex as the GDPR, but they also don't actually address the technology and the processing side of what the DPO is responsible for. So we've combined both legal, regulatory and compliance content with technology content, which does give us a bit of an edge in terms of the market. And certainly in our current state at the moment, we're the only leading business school that's providing this solution, if you like, this training program to the market. So fundamental to the regulation, you'll hear this time and again, is actually the role of the data protection officer. I'm not expecting you to read what's on the slide, except to say that the duties and responsibilities of the DPO are very clearly laid out under Article 36 of the GDPR, the General Data Protection Regulation. And interestingly, an important word in that screen is actually expert knowledge. This is, again, something new. There is a requirement under European law now that the DPO maintains her or his expert knowledge. That's actually mandated and a requirement. If they fail to do that, there's actually an administrative fine that can be levied against the organisation. So they're taking this issue of training, of making sure that we learn from our mistakes if there has been a personal data breach. They're taking that really seriously, and that's part of the principles behind this new regulation. It is reasonably prescriptive, but it is a regulation. The difference between a directive and a regulation is very straightforward. A directive has to be incorporated into national law. A regulation takes effect without any enabling legislation. So it really becomes law as soon as the ink is dry, and we have a 2-year transition period to fully implement what's in that regulation. A lot of the principles of the GDPR are actually based in good governance and good corporate practice. So for the vast majority of you today, this shouldn't be a big deal. This shouldn't be a massive effort to comply. Yes, there will be some changes required, and I can highlight what they look like, But ultimately, if you're acting in an ethical way, that you have good processes and procedures which comply with best practice in corporate governance, this shouldn't be massively painful for you. However, we are talking about a state of affairs where we're not stationary. In the next 24 months, all of your organisations, irrespective really of which sector you're in, all your organisations will have to go through some form of transition in terms of understanding your responsibilities in European law with respect to data and holding that data lawfully within your organisation. That means you're going to have to go through a performance curve, and that's steep really to start with, and then through the course of the next 24 months that will then plateau out. So really speaking, right now is the time to start thinking about the changes that you will require to be made. Part of that would be an appointment of a data protection officer. It also, as I've said, throws up a number of other decisions that you need to make, and one of them, quite importantly, is actually having an appropriate level of budget to service your legal requirements under this regulation. So, in a sense, this regulation, which started life in 2012, is now just about to get its final second reading in the European Parliament and become live in order to transition to the full implementation of GDPR. The race really is on now. And again, our program at Henley really navigates someone who's in that responsibility to really understand what they do from a practical perspective during this 2-year period, but also from an organisational development point of view, how the organisation needs to change. And because we're a business school, we quite like diagrams like this. It's about strategy. So clearly, we're on a new compliance journey. We've had compliance in the past, but this is a completely new compliance journey. And so that's something which needs to be unpacked and thought of. There's also a greater degree for transparency under the new regulations. So things that we used to do in the past without getting explicit consent or consent just don't work anymore. So transparency is definitely a core principle for this new regulation. And then there are new enforcements and sanctions and remedies, and it's very, very, very easy to trip up on a number of tripwires that are contained in the General Data Protection Regulation, and it's really important to understand how to avoid doing that. So again, don't expect you to read this slide, but if TalkTalk had been operating under the General Data Protection Regulation, certain things would have happened to it. And certainly, it wasn't the first breach it was at the wrong end of. It was the third breach that TalkTalk had, and it certainly would have resulted in a significant financial penalty. And remember, under the General Data Protection Regulation, if you are a recidivist offender, there is the option for the regulatory board and the supervisory authority to remove your license. So you may not be able to continue to trade until you comply with the regulation. That, if you like, is significant business continuity risk for not getting things right. So again, the training program looks at that in some detail in terms of what lessons can be learned, what case studies are happening as we walk through this whole training program, and taking those relevant learnings into our program. So, some core principles, if you like, again, not to dwell on it. Personal data, the whole definition of personal data has changed. So an IP address, even your own biometric data can be regarded as personal data. Data controllers and data processors, they have their own duties and responsibilities, but they are also severally and jointly liable for data breaches. This is absolutely new, and actually puts a huge burden on the data controller to ensure that anyone they use, whether that be a cloud provider in the UK or Tata in India, they have to comply with the principles of the Data Protection Regulation, irrespective of where they're based, whether they're in the EU or outside the EU. The General Data Protection Regulation also encourages certain types of behavior. Again, this is a bit of a game changer. And security actions that might be considered appropriate to the risk need to be taken and need to be done. There isn't, whether you should do them or not, you have to do them. So things like pseudo-anonymization and encryption. Pseudo-anonymization sounds like a weird word, and we're going to get used to these concepts because they're going to become much more important. There are businesses that basically profile us, and they're also going to be affected by GDPR because that kind of data, the kind of thing that you might go onto Amazon and shop, they've got personal information about you, which is special data. That's classified as sensitive data, and they've got to get your explicit consent to be able to use that data now. There's also going to be other things which are more consumer friendly, and that would include things like this. This isn't the actual logo, but there's going to be a logo that organizations can use on their websites and their material to demonstrate that they comply with the General Data Protection Regulation. And you can apply, and it will be independently assessed to get that stamp of approval. But guess what? If you fall below the standards required of maintaining it, not only will that shield mark, that logo be removed, but it's also a matter of public record. So any organization that applied for it and achieved it and then had it removed, that is in the public domain. So consumers can find out who they want to buy products and services from and check a register. And this is for all organizations across the European Union. Fines and enforcement, it's a completely different regime. The supervisory authority, previously known as the Data Protection Authority, will have sharper teeth to enforce sanctions and fines against all organizations. And believe you me, they will. The other thing you have to remember is this is one regulation for all organizations across the whole of the European Union. So there aren't going to be 28 different data protection and regulations across the whole EU. There's going to be one. And so it's going to be interpreted in a consistent way because part of the principle of this is harmonization of the single digital market. So without having a framework around the single digital market, it can't exist. So irrespective of where the breach occurs, a consumer can take action and get a remedy against the data controller or the data processor. There are a number of principles. Again, these are all potentially quite new for many of you. A risk-based approach, which means we've got to take into account the data we're processing and how much of a risk it is for a data breach to occur for that particular individual's data. So it's a risk-based approach. We've removed the requirement for notification to the DPIA, the Data Protection Authority, in advance of processing data. That's gone. But in its place are a set of principles where you have to comply to a higher standard. So although we've got rid of some of the red tape, we've raised the bar in terms of data protection and privacy. Privacy by design is another concept that you will come across amongst others. And of course, this also applies to something which you may have picked up on called the Internet of Things. So if the Internet of Things, like cars and fridges, are collecting personal data, you need to have given your explicit consent. A lot of the time, that doesn't happen right now. And then right now, if you like, is the data protection impact assessment that needs to be undertaken by your DPO. So the future of big data relies on being able to take data from your customers and pseudo-anonymize them so they can't be identified if you're running that data through your processes. So you can't identify someone from their individual characteristics and their name and their personal data. And that's really important because a lot of businesses rely on processing big data. There are two grounds for consent of data processing: consent and legitimate processes. You're going to also read an awful lot about relying on legitimate processes, but actually that isn't going to be sufficient because that's almost like implied consent, and the whole direction of travel for the General Data Protection Regulation is actually to get consent. And so for an awful lot of you today, you might have people on your database who've consented under the previous regulation that would probably need to be reconsented. You might have exceptions under the General Data Protection Regulation, but they're not that reliable should you face a personal data breach and you're relying on legitimate interests. So just bear that in mind. I'm running up against the clock and the speakers beside me, so I'm going to skip really to talking about the data protection officer, because actually right now that's the biggest decision that any organisation needs to make, is actually who do they employ as a DPO. And it's very interesting. Currently we have people called DPOs, data protection officers. This particular individual gets paid a huge amount of money, is independent within the organisation, has to report to the highest level of management authority, and that means the CEO. They're also unable to take instructions from the board, and they are under an obligation to report every personal data breach to the supervisory authority. So if you like, they're a bit like a mini regulator sitting in your organisation. Now there are obvious caveats to that. Small organisations of less than 250 employees don't have to employ a DPO unless they are processing vast amounts of data or they are processing special data, that's sensitive data, in which case they do have to employ a DPO. So, very quickly, there are changes in terms of how you record data. There are new conditions for satisfying lawful processing, and there's a huge amount of detail regarding that. You have to conduct a data protection impact assessment. You need to plan a proper data protection training program, not just for data protection staff, but for general awareness within your organizations as well. You need to keep meticulous records. So for example, if you've got consent from people to use their data, did you give that consent in language which was intelligible to them? How long did you say you would keep that data for? And you have to give them the option of saying, I no longer want you to keep my data, and that has to be just as easy as giving consent. You basically have to protect the rights of the data subject. It's no longer a nice thing to do, it's a legal requirement. You need to watch for the danger signs, and there's a huge number of tripwires within this detailed regulation. You need to plan for a data breach, and one of the things that we're doing is we're stress testing what organizations need to do in the light of having a personal data breach so they don't get whacked by the supervisory authority or their regulator. And you need to keep your senior management team informed of the changes that need to happen within your organization. If you want to know more, we've got copies of this program. We're literally around the corner. And if you've got any questions, thank you very much.